What's up, everybody, and welcome back to another episode where John is popping on every time he logs in, and we are talking about Karen Read. Verdict Watch is on and official, but some wild stuff happened today, and I got to be honest, if I didn't say this is incredibly interesting to me, I am really looking forward to breaking this down and talking about this with you. Alan Jackson was pissed at the judge about the verdict form. He has some very obvious and legitimate reasons for being pissed, but some other ones we're going to dig into. Is he right? Is the judge right? And why? What does it look like in other cases? Why is this so important? And how did we get here at this point in the trial? I'm going to answer your questions. We're going to look at a lot of different things today to break this down, hopefully help you understand it more. So let's jump into it. So I think to start out, just to frame what we're talking about, we're going to take a look at the verdict form. But before we do, I just wanted to tell you kind of where I expect this video to go, what I expect us to be able to look at and break down. I want to look at the verdict form itself. We'll look at it a couple times. We'll look at it in the beginning to frame it and then back after we hear some of the arguments. We're going to watch the exchange between Jackson and the judge, what they're asking for, how we got here. Then we're going to come back to the verdict form to discuss it some more. And then I'm going to show you kind of just a standard normal one of these in Florida to discuss some of the differences, why they're there, what's important, what's not. And then to finish, I want to listen to the judge actually explain the charges to the jury in the jury instructions so we can see if she hit all these points and if she made it clear that you can check the box for not guilty, and that will include all the other charges. Sometimes judges read the verdict form, sometimes they don't. I didn't hear the judge in this case read the verdict form, but she did explain what is necessary to convict Karen Read on the main charges and the lesser includeds. So I think it's important to listen to that as well, and we're going to do that at the end, and then probably bring up the verdict form one last time to go through it to see where we're at. And I think that's really important. I know people are going to be coming on and they're going to be asking questions. So we may have to repeat some of the stuff, and that's okay because I want everybody to get their answers to their questions. But it is funny. Somebody made fun of me the other day for pushing back my hair so much. When I see it's like crazy, it's a little out of control, has a mind of its own. But I want to try to answer as many questions as we possibly can through here. The bat signal was loud and proud in the sky when this happened. And so we had to hit it. Not a lot of time to digest it and think about it. I was able to talk to my dad about it a little bit, just some of the differences and things that we've done in our cases. So that was cool. And we'll kind of discuss that as well practically. And because lawyers, like, we can talk practically and what we think is going to happen and will this actually affect the case. But then there's also this whole other world of appeals and justice and doing it fair regardless of what the outcome is. And it's hard to balance those sometimes. We will try to do that as we break this down. So let's first get into the verdict form. So here it is. This is for second degree. It is very simple. Guilty. I should say, I'm sorry, not guilty or guilty. Next is the important one. This is the one that the argument is centered on. This is count 2, manslaughter while operating a motor vehicle under the influence. I would say even people that really think this is going to end up being a guilty verdict, most of them agree that the intent aspect of second degree is going to be really difficult and probably wasn't proven. So if there's going to be a guilty verdict, it is likely going to come on this form, either from manslaughter or one of the lesser includeds, which makes this all the more important as we take a look at how it is drafted. In the above styled case, we, the jury, say the defendant is first either not guilty or guilty of the offenses charged, manslaughter while operating a motor vehicle, check one or both, manslaughter while operating a motor vehicle under the influence, or manslaughter while operating a motor vehicle with blood alcohol level above 0.08. Then we go to number 3, guilty of a lesser included offense, involuntary manslaughter. And then number 4, guilty of a lesser included offense, or I should say lesser included charge of motor vehicle homicide. And then again, under the influence or above a .08. So that's how it's drafted. It's just going to frame it. Take a look at it. We're going to discuss what it means, what the issue may be, what the arguments are. We're going to get to all that. But I wanted you to see what it looked like before we listen to the argument. And then offense 3 is just, again, guilty or not guilty of leaving the scene of the accident resulting in death. Okay? And don't worry, we're going to look at this again in a little bit. So now let's take a look at Jackson's argument with the judge this morning. That just happened recently. Before we get there, a lot of questions already pouring in. Tangling with Gina. Yes, everybody hit that like button and subscribe if you haven't already, because if you like and subscribe and you ask questions and things pop up like this, I'll jump on them as quick as I can. Deb K said, make it make sense. That's going to be the goal. I'm gonna listen to the arguments before I answer some of these other questions, though. All right, so here we go. This happened this morning.
What is back to session? You may be seated.
22117.
All right, so why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments the court indicated it would make a.
Oh, no.
Before we even get to her first comment, he said, Judge, I just saw the verdict forms. That's wild to me. Jury instructions and verdict forms in cases like this, just so you know, they go through 20 different iterations. We edit this, we redline that, we propose this, the judge hears this, makes a decision on that, there's an argument from that side, there's an objection, whatever it may be. So it's not unusual for something to happen and it's like, wait a second. That's not what we agreed on. And sometimes we fix it. How they did not see the official verdict forms that went back to the jury before today is mind-boggling, and I don't know whose fault it is. I don't know if it was there in the packet and the lawyers just didn't look at it. I don't know if what they were looking at is not what went back to the jury, which would be a major appellate issue. Or I don't know if they all were okay leaving something up in the air and just letting it go back to the jury. I would venture to guess that I've never let a piece of paper go back to the jury in the jury instructions without reading it first. You have to read the final version. I usually follow along. And by the way, when we watch the video near the end of this video, when the judge is reading the instructions and the charges and the elements of the charges, we'll take a look and see if they're following. As boring as it may be, I'm following. I'm going through, or if I'm not, I'm making sure co-counsel is. Read every single word. So Pamela said they looked at it yesterday and asked her to fix it. So we're going to get to that. But regardless, if they didn't get it officially and look at it before, you are absolutely allowed to do that as a lawyer. Say, Judge, I don't want anything to go back to this jury until I've seen it. They have to allow that. So if the judge just said no, that's a huge, major issue. If the lawyers didn't ask, so I really would like to know how all that happened procedurally. All right, let's keep listening.
As we discussed yesterday, the amendments the court indicated it would make a.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
What you said before you were tired and you needed to think about it was you agreed.
So Karen Reed does smirk there, and just wait, more on that later.
That there needs to be not guilty options for subordinate charges under count 2.
So here's what he's asking for. He wants each charge, as we just looked at, and let's take a look at it again. No rushing through this. Let's just take a look at it. So he wants each one of these lesser included charges to have a guilty option and a not guilty option. So it says manslaughter, guilty, not guilty box. Involuntary manslaughter, guilty, not guilty box. Vehicular homicide, guilty, not guilty box. That's what he wanted. That's what he expected. That's what he asked the judge. And that's what she indicated to him she would likely do, but then didn't do. Okay. So just to set the scene so you can know what it looks like, what he expected, what he wanted. All right, back to the arguments.
I said that it made sense to me, but no, I did not change it upon looking at it because the verdict slip This verdict slip as submitted to the jury is exactly how it always is in Massachusetts.
Can I ask you a question?
So she says, this is exactly how it always is in Massachusetts. So obviously, I've never tried a criminal case in Massachusetts, but I've tried some in a lot of different jurisdictions. My dad has also tried them in a lot of different jurisdictions in a lot of different states. And I will just tell you, she's not completely wrong. She's not completely wrong in that it is more common than not in all of the jurisdictions we have had cases in with lesser includeds for them to have multiple lesser includeds, but one not guilty option. Now, it's not exactly what she said, and definitely not exactly what they did here. So while part of what she's saying may be true, we'll dig into why it is still an issue and how we should do it better and how easy it would be to do this better and to do this the right way. But her comment that this is the way that we commonly do it is not just completely false. In a lot of jurisdictions, I don't know specifically for her courtroom, but she even asked Mr. Yannetti, which makes me think she's confident. And Mr. Yannetti's saying no to it is, again, not really completely confident either. So it leads me to believe that she's probably not completely wrong that there's usually one not guilty option, but this is not the best way to do it, in my opinion. We'll talk about what I think is.
I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Jackson says, and I'm going to back it up. Sorry, I'm stopping it every 10 seconds. I mean, there was fireworks here in a very short amount of time. He says to the judge in open court, on the record, with the cameras on, I don't care what's normal in Massachusetts. And you know what? He's right. I don't care how you've been doing it, Judge. We want to do it right. Because guess how you get into a rut sometimes? And guess how lawyers get sanctioned? By using samples that they've used and templates that they've used and say, oh, this is what I always use. Doesn't mean it's not wrong. Okay? And number two, something I want to touch on as well, when I talk about jury instructions going back and forth and back and forth and back and forth. But the option on what you can do with a verdict form is almost endless. As long as it is within the law and a proper explanation of the law and the charges and the elements, you can do special verdict forms to make sure it's absolutely clear. I'll give you some examples of some that, again, we've seen in Florida and used in other cases, different verbiage to make it absolutely clear. Because why not? Why not make sure we get this right?
To the jury is exactly how it always is in Massachusetts.
Can I ask you a question? I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Different things.
It's appropriate.
Let me make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge. And that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check.
All right, before we get her answer, let's take another look, one more look here real quick at the verdict form to talk about what he's talking about. So he's saying, I get it. If they want to check not guilty on this superior charge, they check box number 1. But once they go to box number 3, if they want to check not guilty, they have nowhere to check not guilty. That's the argument he's making. I don't necessarily know that I agree with that, but that's the argument he's making just so you can visualize it. And now here's the judge's response.
How do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty. And on the top, you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's
Of course, she's not wrong there, right? Of course, she's not wrong. If they only check not guilty and all of the other boxes don't have checks on them, then it's not guilty.
how it is, Mr. Jackson.
Well, apparently that's how it's going to be because of the court's ruling. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Ms. Giannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't really.
Have you had no lesser included?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option for the rest.
Okay. I disagree with you. All right.
I don't see
Excuse
He says he hasn't seen it. Interesting.
me. This is funny, Ms. Reed. All right. We're done.
I don't see
Excuse me. This is funny, Ms. Reed.
Then she takes a shot at Miss Reed. And there were some rumblings the other day about a juror having a problem with Miss Reed smiling. And so I don't know if this is going to make that worse, if anybody in the jury is getting talked to by anybody watching on the outside world, but not great for her to smile and laugh, not great for the judge to comment on it, just all around not great.
All right. We're done.
All rise for the court, please.
And look at everybody back here, just like kind of chuckling and laughing. So we've heard there is a jury question. So we'll go ahead and pop live and leave it spinning as we discuss. I don't like that one. Whatever. We'll just leave it like this. Okay. So that's the argument. That's what the judge said. If there is a question, we have the stream up here and we will watch the question together. But let's dig into this a little bit more because there's some important distinctions here, some agreements and disagreements with, I think, how all this went. Again, my first and most important problem is that they didn't know about this or didn't have this all settled prior to it going back to the jury. And I don't know whose fault that is.
Session, you may be seated.
All right, here we go.
Judge, we have a question for the
This is live, by the way, and this is a jury question. So we'll take this, we'll keep rolling, and then we're going to get back to the verdict form.
jury. It's been marked QQQ for
Okay.
identification.
So, question, can we request the cert report detailing the search performed? So they can request it, but they can't get it. So I'm just going to say you have all the evidence in this case.
So the cert report on the search form, on the search that happened, was the guy that came and testified, the special search team, they're experts, shoulder to shoulder, 6, 7, 8 guys there, some of whom we don't know who they are, walking through the yard. They picked the exact location based on what Tully and everybody else told them, where the body was found, where the evidence would be, where later evidence was found by Proctor and others. They stood shoulder to shoulder, walked through the area, searched every inch, and didn't find, 30, 40 pieces of plastic that later was found by other officers just happening to drive by. That's the report they want.
We'll figure that out. I'll get some language from you. But Mr. Jackson, after our hearing this morning, I considered what you
Oh no. I wish I would have given my opinion before she's going to do what I think she's going to do.
said. I went back and I read the jury instructions I gave yesterday. So
That's
I
exactly what we were going to do later, Judge.
do appreciate the concern about the confusion this might cause the jury. I think it's easily clarified with the supplemental instruction. I don't think it's the verdict slip. I think it's how they're to follow the verdict slip.
This was going to be one of the ways I said she could remedy it. Okay. Could change the slip. You could give a simple instruction to the jury to make sure that they know that not guilty means not guilty of everything and not just the superior charge. So we'll listen now to them discuss what corrective instructions she should make. I'm so glad she's doing this. It is such a simple fix. You do not want this to be an appellate issue. Worst case scenario, they check not guilty and guilty of a lesser included. It's an immediate automatic appellate issue if they then erase the not guilty check and we can see the outline there or the cross out. That's just prototypical appeal. I don't know how you lose that appeal as the defense. So there were some major issues. There's also some hung jury issues with this that maybe she'll fix here, maybe she won't. If they're not guilty on the superior charge, but hung on the lower charge, how do you prove that? How do you prove double jeopardy? Can they go forward on the superior charge? No, if they check the not guilty box, but if they leave it up to interpretation, that's an issue. Let's see if her corrective instruction explains all this. I feel like Lally and Jackson trying to squeeze all of my opinions here in 1 minute before we hear what she actually does.
So what I've written up, this is a very rough draft. I'll read it to you. I'll take a break and let you consider it if you want. And this works out. I received this, 15 minutes ago, and I've been the question from the jury. So it seems a good time. So I was working on this. It seems a good time to bring them in for an answer to that question. And I would say, as long as I have you here, I want to clarify my instructions regarding your verdict as to count 2 of the indictment. As I instructed you yesterday, there are 2 lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony, OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor. And if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. The lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proved all 5 elements or proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony, OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all elements of manslaughter while operating a motor vehicle under the influence of liquor, and has failed to prove all of the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2.
That is so many words and so confusing, so much more confusing than just having 2 little check boxes or doing some of the other options we're going to talk about at the end of our video. But let's see what the lawyers think of that.
Yes.
They've got to think about it, right? She's just sprung this on them. And we like to review, edit. Words are important. Definitions are important before we make an argument to the court. But let's see. They're huddling. Let's see what issues they have.
Thank you, Your Honor. May I be heard?
Yes.
I deeply appreciate the court's additional clarifying language. I would simply ask for one very simple amendment, and that is at the top of the verdict slip, it says the 2 words, not guilty. We would ask that the verdict slip read, not guilty of the offense charge or any lesser included offense.
Gosh, that's literally exactly what I was going to say. Dang it. It would have been so cool to do that before. I'm going to show you a jury instruction that has language kind of like that.
That's it. And I think that and the court's clarifying instruction would satisfy the defense. That's all I think. I know it will. That's all we ask.
All right.
I can repeat that if the court wishes.
So there are some minor changes we have to make to the verdict slip anyway. Just, the It has to be consistent. So the manslaughter while operating a motor vehicle under the influence, the tab needs to, actually, Tori. So there needs to be some physical changes on the verdict slip. Anyway, it needs to be indented. There needs to be a colon after guilty of offense charged. It's not complete. It doesn't have under the influence of liquor. It just says under the influence. So there are some minor changes that need to be made to the verdict slip. Does the Commonwealth oppose the suggestion made by Mr. Jackson, which seems like a reasonable one?
No, Your Honor.
All right. So it will be not guilty. So tell me again how you want it.
Sure.
You want-
Not guilty of the offense charged or any lesser included offense.
That's the perfect language. And that is what we usually ask for. That's what I was going to say. And if you do it that way, then it encompasses all of them, right? It encompasses all of them. Could still have a hung jury.
I think the clarifying language that I proposed is important.
I do too, and I appreciate that. I think with that amendment to the slip and the clarifying language, I think coupling those up is exactly what the defense is asking for. I appreciate that.
So I need to clean, I'd like to send in a written copy of what I just read there. I have a couple of things bolded. I need to fix this up a little bit. I mean, it was just done quickly. The jury's been waiting. Why don't we bring them in? And I will tell them that a new verdict slip will come into them. How's that? I do, though, have to make a finding that the verdict slip as is was proper. All right, so we'll just leave it at that. I'll make the amendment that you want.
Of course. She has to say it was proper, but she's still going to change it anyway.
But that's my finding.
Thank you, Your Honor. Just from a logistics standpoint, once the new verdict slip is prepared and ready,
We all need to see it.
I was just going to ask, you have that email to us or something?
Yeah, we all need to see it. I will work with Tori. All right. Can we bring the jurors in, please? Oh, I'm sorry. What suggested language on the cert report?
But I'm sorry, Judge.
Any suggested?
They asked if they could see the cert report. She's got to tell them no. Basically, she's asking the lawyers, how do you want me to tell them no? You have everything you're going to get. It's not admissible. The judge won't let it in, whatever. You can figure out whatever language you want to give them as to why the cert report is not available, but you don't want to make either side look bad or like they're trying to hide something by not giving them the cert report.
Language on their question.
No, I think the court's correct that in terms of the cert report request, the court's answer is right on point, which is you are directed to you're directed to review the evidence that's in front of you, and that's it.
I'm just going to say you have all the evidence in this case. We will not give you anything. Okay.
Man, is this interesting. Holy cow.
Rise for the jury. You see it?
All right, so jurors, we're in receipt of your question. Can we request the cert report detailing the search performed? I take this as a request, and the answer is that you folks, you have all the evidence in the case. So what you have is the evidence in the case. You won't be receiving any additional evidence. But as long as I have you here, I want to clarify my instructions regarding your verdict as to count 2 of the indictment. As I instructed you yesterday, there are 2 lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor, and if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. So, the lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony, OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all the elements of manslaughter while operating a motor vehicle under the influence of liquor and has failed to prove all the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2. So I'm going to send in a new verdict slip on count 2 that's just a little bit different, and we have to sort of change the we have to indent something and change the spacing a little bit to make it a little bit clearer for you. Okay, so we'll get that into you in the next 10 minutes. All right, thank you all very much.
So I even think it's kind of wild that without the lawyers looking at it and approving the language, she just read it to the jury. Like, I would have been like, Judge, I would like to read it myself before you even sit there and read it to the jury. But I mean, the fix is better than anything else. And they're going to fix the actual form and put not guilty on this charge and the lesser included, which is really, really important. And I think the best way to encompass it, there are still issues, which we'll talk about. See if anything else happens. And here's Trompin calling the answer early.
Go be recess.
All right. So we are officially back to the fan. And what I think is important and kind of going to just flow seamlessly into some of the other stuff we're going to talk about is the clarifying instruction that she read. I mean, it's just so funny. If you go back and listen to my intro of this and what I was saying we were going to get through, there was a reason and a purpose behind all of it. So we're going to look at this form, look at the arguments, talk about what's good, bad, appealable, what the issues are. We're going to answer your questions, of course. But the reason I wanted to listen to, and we're still are going to, the way the judge read the charges, she left that out. She left out how you go through and come up with not guilty for each of the lesser includeds, how you work through that. Instead, she just read the elements, proven beyond a reasonable doubt to get to a guilty verdict. That was the issue, and we're gonna listen to it ourselves, right? We're not gonna take anybody's word for it. We're gonna listen to it ourselves. And let me just turn the sound off, just in case anything happens in court, and we've got it rolling. So we're still gonna listen to that and see that issue. I'm still gonna show you some other verdict forms. I might not show you all of them since we've seen the language now of not guilty of this and the lesser included, but just some other ways to simplify it and see how lawyers really can write it in a way that is not confusing. It's not confusing. It can seem like a lot of questions, but if you methodically go through one by one, it actually makes it easier. And all these questions about why doesn't the judge just do a clarification? I'm with you guys. I agree with you guys. And thankfully, she eventually did. All right. Let me hit a few questions. Here's how we're going to do it. We're going to hit a few questions. Some of these comments are awesome, so I want to highlight them. We're going to hit a few questions. Then we're going to listen to the judge read those jury instructions while I put some of the comments up, and then we'll come back and read some other verdict forms and some other cases at the end. We'll kind of flip that just so we can get to that since it's fresh in our mind and we just heard her read the clarifying statement. Melissa, what's your opinion on how strongly opinionated some of the media outlets have been and how strongly they are for the Commonwealth? It's crazy to me. I've seen strong opinions on both sides. I get it. I understand everybody's screaming in the name of justice. I think we do have to make sure we are just to each other and fair to each other as well, and not taking it overboard on some people that think they might be doing the wrong thing, even if we disagree with it. So I think there's always the way you approach it. And some people disagree with that. That's how I'll always be. Is this normal, Pita? As a Bostonian and a nurse, this entire trial scared me. I hope I am never in Karen's position, as this has all been handled poorly. So I will tell you, first off, and somebody made a comment about it, technically the judge is not wrong. This has been used in other cases and gotten through appellate muster. But I think the clarifying language is important. And I think even she knew she needed to explain this to the jury better. We also don't know in those other cases if there were clarifying instructions or if there was additional verbiage that went back with the not guilty line. So we don't actually know. So that's why technically they both had arguments that were technically correct, but why not do it right? Nobody's tying our hands. Nobody's saying we can't. So I'm glad they at least made some changes. Can Bev be charged for how she handled this trial? Unlikely, unless there's some kind of, fraud and issues going on in the background we don't know about. Aaron, so what is actually appealable, the verdict or the jury instruction? So you would appeal the verdict because the jury instruction is confusing, and the defense would have argued, basically forced them to check guilty on one of these lesser included because there was no guilty option. I don't know if you would have won on that, but I think if they would have checked not guilty for the superior charge and then guilty for one of the lesser, that's a huge issue. And there might be a double jeopardy issue if there's a hung jury, because if you look at that verdict form, which we'll take a look at it one more time, just to kind of tell you what I mean. Imagine they check not guilty here on number 1 and then guilty on number 3. What the heck does that mean? And they send it back and clarify, and then they just scratch out the not guilty on number 1. Then it's like, holy cow, what? But now if we have it where it says not guilty of the superior charge and the lesser included, there's no ambiguity. And that means not guilty across the board. But if let's say they all agree it's not guilty of the manslaughter charge, but they hang on the involuntary manslaughter. They hang on the fact that it was accidental, or she had no intent of anything, or she wasn't drunk, whatever it may be. What is she going to be charged with and tried with the second time? Because it's double jeopardy if she's not guilty of the superior charge. They can't charge the superior charge. They can only charge the lesser included, which is obviously less jail time, less serious, things like that. But what if we just don't know? Then we could be violating those rights of the criminal defendant, which we want to make sure we don't. So why not do it right? What if anything said LSAT day got a 166, 395 GPA? You're well on your way. Go crush. Isn't the judge paid by the Commonwealth? Yeah, Charlie, but the state is, the public defenders are, and they're all in the courtroom at the same time. It's, hard to get around that paid by the government thing. April, how could she be charged with second-degree murder and manslaughter? Isn't manslaughter the lesser included? Can't be convicted of both. And they are separate charges, so confused. So the elements are different. The intent is different. If you look, actually, because it's not all on the verdict form here, this is a perfect segue into us listening to the judge read some of these charges. And I will answer questions to break some of this up while we listen to her read the elements of the charges. Not all the jury instructions from yesterday, just specifically the elements of the charges, because I want to focus on how she explained, if anything, how you deal with a not guilty verdict here.
All right, that completes my first part of the instructions. Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. Ms. Reed is charged with second-degree murder. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe, or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which...
So that's the big thing, the intent. Did she intend to kill him, intend to harm him, intend to cause serious bodily harm?
In the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail.
Wafa said, Karen laughing is absolutely disrespectful to JOK family. You may not agree. So I said from the jump, I think it was she shouldn't laugh and the judge shouldn't call her out in the middle of court on the record. But I think, if you want my opinion on it, since you're asking, I don't think she was laughing at anything that had to do with John O'Keefe. I think she's laughing because she thinks the judge is in on it too. And she's like, of course. That's what I think the laugh was. Yobi said they're hung on the manslaughter charge because the juror is unable to accept the cover-up theory and don't know another explanation besides KR hitting JK. So that could be the case, but we got to think about the jury question. And what do we learn from the jury question? I think they're discussing the cover-up. And I think maybe a juror is in there arguing for the defense saying, it was a cover up. Think about that CERT team, shoulder to shoulder. They searched everywhere and they didn't find it. The only explanation is a cover up. That's what it sounds like to me, as evidence that a juror or multiple jurors are used to try to convince other jurors of the cover up. That's what it seems like to me. But you guys let me know what you think another explanation could be about asking for that CERT report.
The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe, or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has three subparts, which I will call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that
By the way, you'll see Yannetti looking at his computer basically the whole time, and Jackson's looking at his phone. I don't know, but I would assume, I should just say maybe they are following word for word through these instructions. And what you'll notice is not in these instructions is what to do if it's not guilty each time, where the boxes all are.
defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether Mr. O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result.
So no intent, not guilty.
In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of those elements beyond a reasonable doubt, you must return a verdict of not guilty. The next is manslaughter while operating a motor vehicle under the influence of liquor.
So that was all under the first one, right? So a little simpler, guilty, not guilty. Intent being the big thing there. And then obviously if she hit him with the car. But now we get to the kind of more interesting one that we had the clarifying additional language put on.
Liquor. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements.
I'm going to slow it down just a little bit. Just for the important one.
First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was a 0.08 or greater. You'll have both these choices on the verdict slip.
So she mentions the verdict slip there, how it's going to be she's impaired or it's above a 0.08. It doesn't have to be both. Some people can be above a 0.08 and not impaired. Some people can be impaired below a 0.08. If you're impaired or above a 0.08, you're guilty of DUI. Again, the other stuff is additional to this. But what I also thought was interesting there is she mentions the verdict slip, which is of course interesting. And number 2, we get some of the differences between manslaughter and intentional bad act, which is second-degree murder.
Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. And fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. So to prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle.
I mean, just that. Just her operating the motor vehicle, I would like to have a discussion on if I was a juror. Did they prove she was the one driving? Now, the defense didn't really put up a big fight on that, and they said she did drive home. They almost maybe admitted it, but I don't even think that was absolutely clear, to be honest.
Vehicle while doing all of the
I have had cases where if it was this unclear, that would be my main argument in a DUI.
own things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for
You
example,
take all this time to define what a public way is, right? And this is another reason why I want to listen to this and watch this. It's like, take all this time and energy. And again, I think it's important. They have to prove the elements. Let's make sure the jury knows what a public way is. But it's like, we took all the time to do that, but we couldn't take the time to make sure that they understood how to check guilty or not guilty, or what they do if they're not guilty on the superior charge, but guilty on the lesser included, or not guilty on one lesser included, but not others. We couldn't take the extra time to do that. Cried Wolf, thanks for the super chat.
interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was a 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they've consumed enough alcohol to reduce their ability to operate a motor vehicle safely, by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that their ability to drive safely was.
In fact, she drove the opposite. She controlled her car going 24 miles an hour, 60 feet, hitting exactly what she wanted to hit, right? That's the Commonwealth's theory. Doing that while under the influence.
Finished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this first theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed any alcohol. However, no matter what the reading is, the blood test is not sufficient itself to prove that the defendant was under the influence of alcohol. Now, under the second theory, and again, both will be on the verdict slip and you should decide each one. The Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was a 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who.
Did you notice that? Whether the test was admitted in a reasonable time after operation of the motor vehicle. 9 hours. I don't understand how, like, categorically and based on precedent, that is not the case. Because it certainly does not seem like a reasonable time to me. But maybe it's because my experience in knowing how quickly they usually do it. Maybe that's not fair. If you guys haven't hit the like button, hit that like button. And make sure you subscribe, especially if you're new. And let me know if you're newly subscribed under this trial.
Who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test. Mr. Court Officer, I know it's traditional to not allow anybody in and out of the courtroom while I'm charging, so I'm going to ask you to follow that at this point. Thank you. It's distracting, and I don't want it to be distracting for you folks, okay? The fourth element.
Especially under this part. This is the important part.
Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently. That is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger or death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's
AKA DUI. You chose to drink, you chose to drive, you know that's reckless.
state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved the element. Here, the defendant must have intended her acts in the sense that they were not accidental, but it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in the category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior.
So you didn't want to hurt anybody, but you also knew what you were doing is reckless and could hurt people, and you decided to do it anyway.
In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition and how well the defendant could see and could control the vehicle, the condition of the defendant's vehicle, what kind of road it was and who else was on the road, what was the time of day, the weather and the condition on the road were, and what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all five elements beyond a reasonable doubt, you shall return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant.
So now we get, that was all voluntary. That was all, she chose to do something bad, basically. This is now transitioning into involuntary manslaughter, accidental.
With manslaughter while operating a motor vehicle under the influence of liquor also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. So I will define involuntary manslaughter. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended.
That's obviously the big common theme through all this, that she was actually the cause of his death.
The conduct that caused John O'Keefe's death. Third, that the defendant's conduct was wanton or reckless. I will now discuss each element in more detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove the defendant intended to cause the death.
Basically, just she intended to reverse backwards in her car at high rates of speed. Nick, I mean, this is the ultimate question. This is the ultimate question. This is how the jury should look at it. We'll see if they actually do.
May consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another person that a person undertakes with indifference or with disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have
So it's a reasonable person standard.
realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined them. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider credible evidence that the defendant was affected by her consumption of alcohol.
All right, let's answer a couple questions here to break this up. Kimberly said, mass government template has check only one of the following 4 choices and then number 1, not guilty. I like that too. Only one of the following 4 choices. So you know, if you check not guilty, you don't check any other ones. I like that. What stops the court from changing the verdict slip? Just the court. The Middleman podcast. What evidence did the jury want to see? The CERT report, basically, of when they did that search with the experts there, side by side, shoulder to shoulder, searching every inch of where they thought they could expect to find evidence based on what the cops told them. Jay, do you expect a civil suit against Karen Reeve from the O'Keefes if found not guilty? I don't know if I expect it. I mean, again, all of the media and the pressure and the stuff happening, it makes it more likely, but do they really want to keep going through this? That would make it less likely. Does the jury question indicate what they're thinking? There's a lot of questions like this. Chris asked, Peter, any guess on why the jury wanted to see the CERT report? So I kind of made mention of it before. To me, it makes it seem like somebody is arguing for the cover-up and using this as part of their argument, saying, look, it's obviously a cover-up. They did this, didn't find anything, and then random officers driving by find stuff. Why even have a court reporter if the jury cannot look at that report? Well, for appeal. Everything on the record goes to the appellate court. If there are issues, we have to have it all typed out and recorded so that we can appeal it and know exactly what was said. In a long trial like this, it seems like unreasonable to ask for the jurors to recall all the details. I agree. It's tough. It's an imperfect science, but we also don't want them to sit back there and reread the whole trial because things can come off differently when you're reading them than when you're listening to them. They take their notes. It's the best we came up with as lawyers trying to make this the best jury system we can. Why can't they see the CERT report? It's not in evidence, probably hearsay, other objectionable issues in it. The testimony is the evidence. Daybreak. Possibly Bev was reluctant to indicate form improper because to do so might provide appealable issue for lots of prior convictions in MA. I don't think she had to say it was improper, but there's nothing wrong with if a lawyer asks you to change something and you consider it and there's nothing legally wrong with it, then you can change it. It happens all the time. That we do things other than the standard verdict forms or standard jury instructions. It happens literally all the time. Also, there's a reason they're the standards and not the mandated verdict forms. So does this mean that the jury didn't have the forms yesterday? Sorry, a bit behind. Yes, I think they did have the forms yesterday. Why no CERT report isn't in evidence? No, it's not in evidence. The crypto lawyer, the fact that they're asking for the CERT report on the search gives me pause. Maybe I'm holding them too high a standard. There's one threshold issue to be decided. Did Karen Reed's car hit John O'Keefe? If not done, I honestly think the way the defense argued this case, the jury is back there asking the question, was it a cover-up? Was it the Alberts? I think they're asking each other those questions and they're trying to figure out what did the defense prove? Even though that's not how it's supposed to be, the way the defense argued the case and presented the evidence, I think they would understand if the jury did want to look into that and see if there really was a cover-up. Or if somebody's saying, I just can't vote not guilty because I don't believe in the cover-up, and some of the jurors are like, okay, we'll prove the cover-up. Based on CERT, does it give you any insight as to what the jury's thinking? Kind of already answered that one. Was it proper for Bev to comment on Karen smiling? I think she should have, if she was going to, she should say things like, everybody needs to remain to remain respectful while they're in the courtroom. That includes the defendant, even if she wants to say something like that. Paw Printed Heart. This is crazy. I still would not know what to do. Yes, she was drinking, but how can it be if the car never hit him? Drinking part is suggestive. Yeah, but there's no just DUI on here. And I frankly don't think they proved that. All right, let's listen to more of the instructions here.
A defendant may have the requisite knowledge, even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and negligence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. So I will define that for you now. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the
And now we're getting into another one here.
following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as I've previously instructed you just moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that could have avoided, that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant...
So this is another point here by Gemma. Another good point that they could be asking for.
Intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or may not have intended to result from her actions is irrelevant. The issue is whether...
Here is the negligent killing. So this is, I think, what most people think is the most possible is either the DUI manslaughter or this.
Whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of road it was, and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The next indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated on a public way or in a place in which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe.
Knowingly collided with John O'Keefe. I mean, that element, in fact, is obviously within and throughout all of these charges. So like a lot of you have already said, that's the ultimate question. They have to consider that. That's ultimately where I turned once we heard the defense experts, where it's like, I just believe the evidence points to it's more likely than not, and I'll just give a civil standard, it's more likely than not that she didn't hit the car, that she didn't hit him with her car. And if that's more likely than not, it has to be not guilty.
Keefe, resulting in his death. And fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed you on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define them any further. Save a little time for you. As a general rule, you are permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the
And as we're listening to this, there's only a couple minutes left. You'll notice the lack of explanation of the point that she ends up clarifying on, which this is highlighting the importance of the clarifying instruction and the change made to the verdict form.
circumstances known to him, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. Now that completes the second part of my instructions. I will now turn to the final instructions. In order for a jury to return a verdict, that is to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are still 14 of you. To avoid the need for a new trial, if one or more jurors becomes ill or has to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case.
So I'm going
Therefore,
to
the conclusions of my
skip the part about picking the alternate jurors, but I think there's a final instruction right near the end of this that I want to listen to as well. Denise said, is she charged with DUI? If so, what about all of the drunk cops? So DUI is part of the manslaughter and the killing, and her frame of mind and her reckless decision-making and things like that. She's not just charged with simple driving under the influence or operating under the influence.
the deliberations, communicating with the court if necessary during deliberations,
Here we
and
go.
since the
This is what
jurors
I wanna
select
hear.
their own anyone, including each other. The jury starts deliberating. It is important that we have extra jurors in the case of emergency. If we did not impanel extra jurors and a juror became ill or for some other reason had to be excused, we would have to try the case all over again with a new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start their deliberations all over again from the very beginning. Therefore, it is important that the alternates not discuss the case with anyone, including each other, for if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not influenced by anyone else. Now, different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own foreperson. In Massachusetts, the judge is responsible for selecting a foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court. The judge is responsible for selecting a foreperson. A foreperson of a jury has been described as...
See, so it says in the instructions, the judge is responsible for selecting the foreperson. I did want to hear that because there was some discussion about that. I agree, ZHY. They have all the evidence. They have all the power. They have all the resources. They should choose what to say, think that they can prove. What this does, in my opinion, is it enhances and encourages overcharging because you can just get them for the lesser included later. And it forces people sometimes into plea agreements that they otherwise would not agree to.
The first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations, however, in that sense is exactly equal with all the jurors. I am going to ask juror in seat number 1, juror number 400. Would you be our foreperson, please, sir? Thank you. When you return to the jury room to deliberate, the court officers will deliver to you all of the exhibits in this case.
Just so you know, he could have said no. He could have said no, and then she would have moved on to the next person that she wanted to pick.
As well as the verdict slips that you will use in returning your verdict.
Gives the judge a lot of power. Usually we have an idea of 1 or 2 people that we think is going to be the foreperson because we pick the jury, we get to know them, you watch their mannerisms. We've seen another case of people have guessed who the foreperson is going to be based on questions and other things. So it's a lot of power for the judge to just pick who the foreperson is going to be.
Your foreperson will be given verdict slips setting forth the charges against the defendant. 12 jurors must agree before you have a decision as to any charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should continue deliberating until you have reached a final verdict on each charge. You should not begin deliberating until all 12 jurors are together in the jury room and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I instruct you that no juror is better qualified to determine the truth of the facts in dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair qualified to determine the truth of
Let's hear this again. Hear this again. It's important and interesting.
this case. Further, I instruct you that no juror is better qualified to determine the truth of the facts in dispute or to deliberate on a verdict solely because of education, background, or experience.
Like if there's a doctor, they can't say, no, that expert was wrong. I know because I'm a doctor. Or if I was on the jury, be like, oh, those lawyers were all wrong. Let me tell you what the law actually is. Forget about the jury instructions. No, not allowed, not how it can be. And if somebody's trying to do that, then of course they should tell the judge.
The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong. But no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of returning a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin conducting an immediate straw vote. Rather, I encourage you not to take any votes until you have completed.
And some people have a problem with that. The judge asking them not to take a straw poll doesn't really bother me. I also don't really care. Like they go in there and they have their initial reaction opinion. I do agree sometimes it can push some follower jurors to do what the leaders are doing, but that happens anyways. Thank you, Netwoman. And I agree. I think that that is really weak evidence of a DUI. Frankly, if this was just a DUI case, I think it would be a very strong case to defend as a lawyer with all sorts of holes, all sorts of issues, even with the videos of her drinking.
A careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not consciously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as a member of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions. So don't be shy or hesitate to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors.
So a couple interesting questions we'll throw up here while we're listening to this. If found not guilty, who decides their sentence? The judge. A couple people asking for a new poll. Daybreak said, can we maybe do a poll, verdict or hung? You guys always love to do this, even though such a small percentage of cases end in a hung jury. But Kelsey, you can go ahead and throw up a poll. Will there be a verdict? I don't know how we can do this. Will there be a verdict? And then put verdict and hung as the two options. So we will post a new poll now while we listen here to the end of, actually, let me hit some questions while I'm here. Nancy, I feel the judge is in over her head. She had an easy out. She has been moved to civil court, but insisted on staying on this case. Plus she has someone involved in others in this case. That's interesting. Sonny, do you think when the judge verbally stated she was tired, it opened her up that she did not give due consideration or provide the defense with an answer introducing appealable issue? No, I don't. Stephanie, can previous offenders come back now and want their case looked at again if the jury instructions were the same as Karen's? So there are limits on timing of when you can appeal. And I just saw another question that's stumping me. So probably not. I would say probably not, unless it was a major issue with the form that they had used in every case and appellate courts allowed them to open it up. But I don't think this is that kind of an issue. Yobi, could Bev have thrown out only the higher charge on DV? That's a good question. I don't think I've ever had that come up where they've thrown out the higher charge. Usually they'll let the state like amend the indictment for the lesser charge. That's a good question. I don't know. I have to think about that. Mulder, verdict today. Do you go live when the verdict is read? If I can, I will. Sometimes I can, sometimes I can't. Peter was in Golf Magazine this month. I actually noticed your little icon this time. I SS'd the cover and posted it as my YouTube picture. Read the article on page 22. Top Florida attorney and golfer. YouTube golfer, hopefully. I would love to be a YouTube golfer. Follow up. I guess what my question is, can she be convicted on second degree and manslaughter? Yes. In cases I've seen, murder is the superior charge with lessers. So in this situation, she can be. I think that's how they set it up, right? I think the answer is yes to that. It doesn't make sense, though. The answer should be no to that. It's the same set of circumstances. I'm looking at the verdict slip right now to see what it says. Yeah, these seem like alternative charges. The way it's written in the verdict form, it seems like they could say yes to both of those. I got to look this up because those seem like they should be alternative charges. Same facts and circumstances. Seems like two different charges for the same set of facts that would end up being a crime. I have to look at that. I think the answer has to be no. They can't possibly be. She can't be convicted with both. I just changed my own mind as I'm thinking. My mind's flying a little bit. There are so many questions. Evil Queen. Karen Reed may just have a nervous laugh. The McAlberts are sitting 20 feet away. If there is a hung jury, how likely do you think the Commonwealth will retry? I just don't know. Usually the answer is yes, they will. In this case, maybe they'll just take it as a win. Like we don't know what happened and then just not. I don't know. How does intent work with drinking? So that can be a reckless act that you intend to do. BB, would the Commonwealth have to prove she hit him for any of the DUI charges to be considered? Yes, because it's not just simple DUI. So it's possible after wasting all this taxpayer money, she can go from being charged with murder to just a DUI. So no, I don't see just DUI on there. Have you ever seen such a thing happen? So yeah, my dad and I actually one time tried a federal case that was 4 weeks long that they said this client defrauded Medicare out of $1 million. And at the end of the case, we proved all those charges were BS and it was like maybe $28,000. And we proved it was negligent. There was no intentional aspect to it, which they had to prove there was. And I think the jury came back with not guilty. And they did come back with not guilty in a federal criminal case, which was wild. But we think one of the reasons is they were kind of pissed that they told them in opening statement it was $1 million. And at the end, they ended up saying 28,000 or something in closing because we had whittled it all down and the judge wouldn't allow them to argue the stuff that we knew factually was incorrect. J. Todd, are the people sitting to the left of the defense tech table John O'Keefe's family? Yes, right behind him, I think, in the camera angle. Linda, you may have already answered this, so I apologize if it's a repeat question. I'm so shocked it's taking this long for a verdict. Your thoughts? It doesn't really shock me. It's a very serious crime. And usually longer verdicts are more likely to be not guilty, even though a lot of people think this one's going to be not guilty. So we'll see. I know everybody's going to be nervous. I thought we'd have one by the end of the day today, but it's very possible we don't. Ellen, was the judge worried about Jackson saying he would appeal immediately? Lawyers love to do that. Sometimes judges worry, sometimes they don't. Chris, how often are verdict forms changed mid-deliberation? It's unusual, but it does happen. Are jurors sequestered once they start deliberating? No. And thank you for helping us understand. So in this case, they're not. In some cases, they are. Do you think it was a mistake for the defense to argue a cover-up? I don't think it was a mistake, but I think they could have woven more reasonable doubt into it. But they know the case better than I do, so we'll trust their theory. Maddie, are jury instructions provided in writing? Yes. My head hurts. Also, why does the law not include some language on the state proving the 5 elements in alignment with their theory? So again, that's something that's more implied. And theoretically, I guess if you thought an expert explained it in a way that was different than what the lawyer argued, you would take that evidence, but you can only base it on the evidence presented. Cheeky. All right, hold on. We're going live to court. We are back. Maybe another jury question. So let's pull that up. Where is it? All right, here we go.
New verdict slip.
All right.
You are unmuted.
Back in session, you may be seated.
Judge, we're back on the record on 22-117. Counsel have both had an opportunity to look at the new verdict slip.
All right. So does the defense say the verdict slips in order?
It is, Your Honor.
Okay.
Thank you. and you should report.
Okay. Does the Commonwealth say the verdict slips in order?
Yes, Your Honor.
All right. So the verdict slip will go in, Officer Delano. I'll let you do what you're doing.
So this is, they're looking at what they changed on the verdict slip so everybody can approve it.
All right, so the verdict slip will go into the jury. I instruct you or Officer Leiden to remove verdict slip for count number 2 from the jury, have the jurors fold it, put it in an envelope and seal it. And we'll bring that in and we'll mark that for identification. I'm also going to send in a transcript of the supplemental instruction I gave this morning. May we mark that? Madam Court Reporter, please. I have copies for counsel if you'd like. Yes. All right, so with that, we'll be in recess. And you'll remember that the jurors were instructed that we won't take any questions or verdict during 1 o'clock to 2 o'clock. Okay.
I missed that last one.
The jurors were instructed in the instructions I gave yesterday that we will not take a verdict or a question from 1 to 2. So everybody's free to go for
Thank
lunch.
you, Your Honor.
All right, to the court, please.
All right. So not a ton, kind of what we knew was coming. And there's a question here that I think these jury instructions are going to answer. Where is it? I can't find it. I'll get to it eventually. Lane, how can crime scene be reliable at all since it was left unattended for hours? Also, no one in the house came out to investigate a death on their street, let alone their lawn. That is an issue. Peter, will the jurors now think they have to choose guilty or cover up? This makes me nervous as it won't be good if they think there was a cover up. I don't think that's what it's going to make them feel. KJAB, neither side admitted into evidence. Obviously, the Commonwealth presented it as evidence through testimony of the expert or of the officer. Lane, does the jury or FP, here we go, 4-person get tips on how to deliberate, or is it all up to them to figure out their process? So that's exactly what the judge is explaining right now. This is as many tips as they get is in these jury instructions.
Now, during the course of your deliberations, you might have a question concerning the law in this case. I'm not suggesting that you will, but you might. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the 4-person and sending it to me by way of the court officer. Because your role as the jury is to determine the facts of the case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible to provide you with a transcript of the testimony, even though we've had a phenomenal court reporter throughout this whole trial. If you send
that's a question people always ask. No, they can't get a transcript of the whole trial. We talked about that earlier in the video.
Question to me, I will respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. We will not answer a question or take a verdict between 1 and 2. You'll have lunch brought into you and decide whether you want to stop your deliberations.
These are all the tips, basically. Don't vote as a straw. Don't do a straw poll at the beginning. Discuss it. Nobody's experience is more important than the others. The 4-person doesn't tell you what to do. These are all the tips and tricks on how to deliberate. This is all they get.
During lunch or deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return tomorrow morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the 4-person should be certain that each member of the jury is in complete agreement with the verdict. After the final vote of the jury, the 4-person should check the appropriate boxes as to each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom where the 4-person will deliver the verdicts to the court. I'm going to see counsel before we reduce your number to 12.
I guess we can watch them do that. Some people had some questions about how they reduced it. Leslie said she was in a jury and they picked the 4-person, I think is what she's talking about. Most all of the cases I have done, that's how it's worked. But there are certain jurisdictions where the judge does. As a jury 4-person who sat on a quad homicide jury, it's hard. There's no need to make it more confusing. Filling out the form is nerve-wracking. I know. And that's why I like to do it. And again, we're going to show one right after this, just with a bunch of different questions that you can do. Sometimes it makes it easier. Robert, the Cotton Eye Joe line yesterday had me good. I was like, I couldn't not. Once I said it, it's all I was thinking too. So I'm assuming all of you guys were too. I think the jurors struggle with no justice for John O'Keefe. If they come to not guilty, have the jurors seen all the KR supporters outside? I don't know the answer to the second question, but I agree. Justice for the victim is something that's on every juror's mind in every death case. Have you ever had a Perry Mason moment in any of your trials? Not specifically Perry Mason. I've had some closing arguments where I was like, how do they not agree with that argument? And a lot of times it just comes down to how big the number is going to be in a verdict on these wrongful death or civil trial cases. All right, so let's listen to how they pick these alternates, and then I think we're done with the instructions, and we'll jump to the other verdict form I want to show you guys.
Could the juror sitting in seat number
It's taken by lot. They spin that, and they pull out a number to see who's going to be the alternate.
3, who is juror 79, step down and take your place as an alternate?
And obviously,
And the juror
they're
sitting
pissed and sad at the same time.
in seat number 2, juror 14.
All right. So, ladies and gentlemen, we need to swear in the court officers. They're going to be in charge of you during your deliberations. I suggest that you listen to the oath that they are taking so that you can be aware of their responsibilities. Now you can swear them, Mr. Clerk.
You swear that you will keep this jury and alternates in some separate but convenient place until they agree, that you not suffer any person to speak to them, to speak to them yourselves, nor ask them if they are agreed, nor suffer them to disperse until they discharge of their verdict, except by further order of the court, so help you God. Thank you.
All right. So, jurors, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you have heard here in the court during trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may now retire and deliberate your verdict.
All right. And away they go. And that's the end of the instructions. Hit the like button if you guys have not already. It's our biggest video ever, officially. 38,000 people total. That's crazy. That's crazy. Not squirrel. Why is the Bowden instruction buried so deep on the doc? The lawyers usually agree to the sequencing and ordering of the jury instructions. There's also kind of standard order when it makes sense. OBG, will the jurors notice they are instructed to think more than Proctor did before deciding? That's a good point. D. Bell, is the jury told at the beginning of the trial that they will not be given a transcript of the trial? Not usually. Not usually. But usually we tell them, like, you have to rely on your memory. We don't usually tell them there's a transcript, but we do tell them the evidence and the testimony is what they have to remember. Their notes, they have to rely on their memory. Are they able to deliberate as they're eating? We always let the jury decide, but I assume that differs court to court. What happens if jurors get into a fist fight? Well, it's a problem. And usually we got to pause and see what's going on. All right. Peter, yesterday the judge said the jurors can't share their notes with each other. Why wouldn't that be? I missed that. They're definitely allowed to look at their notes and then discuss, for sure. How likely is it that they'll hang? What about a survey asking guilty, not guilty, or hung jury? Did we do that yet, Kelsey? Throw up that poll and then send me what the results are. Peter, what was your longest wait for a not guilty verdict? I know we had one that was multiple days. Never had one that has gone a week. I have had a hung jury before on a trial, which they waited a couple days. I think the judge waited 2 or 3 days before calling that one. So I think it would be about 2 or 3 days. 2 or 3 days. 84% say there's 10,000 votes, which is a lot. 84% say there'll be a verdict. 16% say hung. I think that's probably about the right odds that I would put on it. All right. Let's pull up this verdict form and we'll just take a look at it. Totally random case. Not one of our cases. Why can I not see it? It's not coming up. Why is that? All right, I can do this then. Let me see if this works better. Yeah, that'll be better then. All right, let's take a look at this. All right, so here's just a random verdict form in Florida. Pretty standard. A lot of them look like this, but it has some interesting language in it. So, burglary. The defendant is guilty of burglary. If you find the defendant guilty of burglary, please answer each of the following questions, right? So these can be known as just special interrogatories, specific questions that you can add to the verdict form. Did the defendant batter this person in the course of committing the burglary? Was there another human being in the structure at the time the defendant entered? Was the structure a dwelling? Did the defendant carry, use, displace, threaten, use a firearm? Did the defendant actually possess a firearm? Did the defendant charge a firearm in the course of committing the burglary? So these are special interrogatories. Additional crimes can come from them. This is just an example of how you can do so many different things with the verdict form. This is anything but standard, and they're all yes or no questions. Is the defendant guilty of trespass, a lesser included offense? Was the structure a dwelling? Was there another human being? Was the defendant armed? Okay. Or you can say the defendant is not guilty. Attempted first degree murder. Defendant guilty. Did he carry or display use of a firearm? These are for enhancement sometimes. Yes or no questions to make it very obvious. But again, even in this one, lesser included, all three, is he guilty? But then at the bottom, the defendant is not guilty. And I want to show this one to have a juxtaposition of sometimes the not guilty being at the top can be more confusing because you think, okay, I've got to go past that, then I've got to check one of these. If it's at the bottom, you would know you already went through all of these questions, and then you would check not guilty more at the bottom. So sometimes that's a better spot. Then this one's pretty similar with just some special interest there. And then the defendant is guilty of battery as a lesser included crime. The defendant is not guilty. And then what we usually put here is of the instant crime or the lesser includeds, but each one. Aggravated battery. Attempted second degree murder with the lesser includeds. Defendant just not guilty at the bottom. So just having it one spot is not always wrong. And I think that's really important for us to understand, but you can do so much with a verdict form. I had a couple more. I don't think we need to look through, every single one of these verdict forms to give you the idea to understand that you can do so much more with a verdict form than what they did in this case. Not to say that this one is wrong or that this one is automatically an appealable issue, but you can add some clarifying details. You can add some clarifying words, such as the defendant is not guilty of the superior charge or the lesser includeds. And that to me is a really important way to make sure the jury gets it right. We're not trying to trick them, right? We're not trying to confuse them. We're not trying to convince them what to do based on the writing on the form. But I will say most criminal defense lawyers want to push for that not guilty checkbox to be first. And while at times it can confuse them because, they have to go through all three before they can actually get to not guilty. They have to make sure she's not guilty of the main charge or the lesser includeds. But you always have to be careful for what you fight for because every action has a reaction, right? Every decision has a consequence. And as defense attorneys, we want to do what's absolutely best for our clients. And I think they hit it spot on. I think the best remedy would have just put the guilty and not guilty box in each one. If I'm being honest, that's what I would push for. That's what I think is best. That's what I think prevents the hung jury, double jeopardy, second trial issue the best. But secondarily to that, when the judge said no to that, I think the second best remedy is to put that clarifying language, not guilty of the main charge and the lesser includeds. That's just one man's opinion, right? Doesn't mean I know all, doesn't mean I'm right. Doesn't mean every judge is going to agree with me. Every judge, as I always say, disagrees with at least one lawyer in the courtroom most of the time because they wouldn't have to make a decision otherwise. Right? I mean, that's really what it comes down to. Also, if you remember from like the Johnny Depp trial and some of the other trials, I'm trying to remember what the other one was at Murdoch, but some of them have specific questions that help you break down yes, 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 then guilty, or no, 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 not guilty, whatever it may be, or one no equals not guilty. I like that too. If you really want to be specific, you see that more in civil trials than I think criminal trials. But I always think it's interesting when that happens. All right, Kelsey, I'm going to hit some questions here now. I'm going to pull this down. If you guys are going to bounce during the question and answer portion here, please subscribe on your way out. I really appreciate it. Margaret and all the new subscribers. I love having new people join, new voices, new opinions. I really always appreciate it. I like disagreement. I like respectful disagreement. I like people bringing different ways to look at it. I feel like I learn from that. And I hopefully you guys do too. 392,000 subs is crazy to think we could be inching our way towards 400,000. If everybody subscribes that watches this, we'll hit it in no time. What kind of civil suit options will Karen Reed have regardless of the outcome? So not a lot if she's guilty. But what I will say is I don't want to kind of go through that until the verdict comes down, because if she is guilty, then I wouldn't feel right going through what's potentially available. Liz A. Peter, have you seen judges tell jury not to do a straw poll, start deliberations? Yes. We've seen it in cases that we've watched together on YouTube. Can Karen still sue if there's a hung jury? Potentially, but it's a lot less. Like, she can argue she's innocent and prove the cover up, even though it's not really what happened if it's not guilty. Hung jury is difficult because then it's at least shows the Commonwealth had a good faith basis and a good argument that they believe she did this. Is that the Alberts sitting behind the family? Yes. Well, I'm not looking at the camera, but they are sitting in that vicinity. How do jurors remember timeline, testimony, notes, and on their memory? Yeah, that's literally what we ask them to do. I know it's tough. Do judges add lesser included when neither attorney ask for them because she thinks the defendant is guilty of the lesser? So no, not unless, like she said in this case, it's automatic. So attorney can request it and a judge can make the decision, or it's automatic. Dove's house. Colin Albert's past altercation with John O'Keefe not brought up in court. I think they were brought up as much as the judge would allow them, or discussed by any commenters. Why? We did discuss them when they were brought up in court. We only know what was brought up in court and what the judge allowed. This case is the very reason why I never want to leave my house or hang out with anyone. Humans are despicable. It can be scary. It can for sure be scary. Why not put jury instructions in layman's terms? We try to as best we can, but lawyers argue so much about words and definitions. It's regular, random people selected to the jury. Unless you have had experience with the law, those instructions are not clear. We honestly do try to make them as clear as we can, but it's an imperfect system. OJ verdict. Yep, it did happen. Do we know what asked of the jurors for selection? I don't know if it was televised. I don't know what was asked. I can only guess based on my experience. Hannah served on a jury in Lawrence, Massachusetts. Tried to schmooze out of it by saying I was biased. Judge called me out on it, made me serve, and made me the foreman. So I will tell you, judges do not like it. And sometimes they do call people out. And if they can kind of sift through and see that you're not actually biased, it's a lot higher likelihood of a chance of you being on the jury. Karen deserves the OJ verdict. Okay, that's what she meant. 8K to 400K, you've earned it. As AJ says, shame on you if you don't subscribe. No shame thrown here, but I would appreciate it if everybody did subscribe. It's awesome when you do, and I appreciate it when you stick around, hit that reminder bell, and come around for future trials as well. We are also, just FYI, keeping an eye on the court feed. If anything happens or verdict comes out while I'm live, we will stream it. KR smiling and laughing throughout the trial bothered me. It looks arrogant and like she's not taking this seriously. It would upset me as a juror, same as Jackson Snark versus Lally's folksy demeanor. I did not personally like Lally's demeanor. I can understand some beef with some of Jackson's. I do agree. I think there were at times kind of a smug feeling from Karen Reed, and we'll see if the jury picked up on that or if it makes a difference. It might not. I still don't understand how involuntary can be an option considering the Commonwealth says it was on purpose. They either proved it or they didn't. It is frustrating. Oh, Ben, what do attorneys do all day during this? We just sit in misery and sweat. We actually do, or what I do, I can only speak for what I do and people in my firm do. I work on other cases. I grab my laptop, I sign in, and I work or I eat. I do something to decompress, listen to podcasts, whatever it may be. Molly, Lally said in closing, Karen Reed is guilty of all three charges. You're right. I just can't put it through my brain. I've got to think about. That's one I've got to sit and think about. I was in a jury that in Dedmond, Mass. That's wild. Thanks for your thoughtful and fair coverage of this trial. I did my best. Not everybody agrees with you, Murfetts, but I appreciate you. Does her research. God bless John O'Keefe. Rest in peace. Agree. Orlando, any guilty charge means the state proved that she hit him with the car. And we all know the state did not prove that. If any guilty charge will be comparable to the OJ verdict, outrage loading. Yeah, I think there's going to be some outrage. There's a guilty verdict, but we'll see. Not guilty, just like OJ. You told us you would tell us where you stood after closing. So not guilty or guilty. Thank you. Yes. My vote at this point would be not guilty if I was on this verdict. And if I was on this jury. I don't know. I feel like it's more likely than not, based on the expert testimony all the way around from the Commonwealth and the defense, that he did not die from injuries sustained from getting hit by a car, and he did not get hit by her car that night based on where he was, what he looked like, what the injuries were. That's why I would vote not guilty. In Texas, for a federal case, we picked the 4-person, and somehow at 23, I ended up as that for a workers' comp case. A lot of it has to do with people have certain personalities as leaders, and those are usually the ones picked as 4 people. Nancy, I feel bad for the O'Keefe family, but I don't feel that convicting an innocent person is justice. Having the Alberts and McCabe there yesterday was to sway the jury. Can it be an argument on appeal if a jurors decided to ignore factual scientific evidence? So they can appeal that no reasonable jury would ever find for a guilty verdict. And if the evidence is really that strong and strong enough, even in the light most favorable to the state, that it would be a reason for an appeal potentially. So it can, if it's that bad. It is very, very, very unusual. I will just say very unusual. Kelly said, I just got my lawyer, cap. I love it. I've got a couple hats that I love as well, where I'm playing pickleball, playing golf. Just me, once on a jury in one of your trials. You were? That would be interesting. I'd love to know about it. Love to know what you think. Shoot me an email. Kevin, you there yet, Peter? Also, please get back to me on the ATP when you can. I haven't finalized signing up with them yet. So there's nothing I have that would make you not sign up with them. John, forward me the email from Kevin if you got it. That Turtle Boy assault video made the Alberts McCabe's look like a bunch of bullies, etc., and they were sober. Welcome to all the new members. Tons of new members today. Go back and watch yesterday. We read some mean tweets and comments. The members only live. Would love to hear what you guys thought about that. We do one every month. We do some other fun stuff with the members. So welcome to everybody, and thank you to everybody that did join during this trial. It's always awesome to see that support and realize, even when there's some really nasty people and things out there, that a lot of people are awesome. And I really appreciate that always. And it's always a small percentage of people that are jerks, even if they're loud. So I appreciate all you guys coming. I'm losing my voice. If the verdict does come down later today, I do have 2 or 3 meetings this afternoon I have to do that I can't move. But if it comes down when I'm available, I will jump on as absolutely soon as I can. I am going on vacation tomorrow. If the verdict comes out when I'm on vacation, I will absolutely go live at some point. I don't know if it'll be live streamed, but I will definitely react to the verdict. Lally lied about the DNA evidence and KR statements according to witness testimony, etc. My question is, does the jury get instructed to ignore that? The jury is always instructed to rely on the evidence and their memory of what they saw or heard from the evidence. They can obviously watch the videos and look at the pictures to see if there's anything inconsistent there. Not that Mickey. How about the law enforcement friends of John letting him drive with someone who's supposedly under intoxication? Seems like a lot of them were. They were all intoxicated that night, in my opinion. Only she gets a DUI. So I think that might be one of the reasons why they don't just charge her with simple DUI. Blessed Mom from Texas. Peter, I must say you're hot. My husband is Peter as well. Hey, awesome. I had to put the jokes. This case is wild. Karen Reed should be not guilty. Thank you for all your coverage and on all the cases. Praying for Karen Reed. What constitutes a hung jury? How much time? So every judge is a little different. We'll see if they do an Allen charge or if somebody objects to that. I think the defense unusually is the one probably pushing for a verdict even more in this case. But we've got to let them go a couple days at least on an 8-week trial. I would think that she probably won't charge them till it gets close to the weekend. But we'll see. Sometimes the jurors say we're at a deadlock and we need to call it. So it's not always just up to the judge. Charlie, with all these instructions, don't you think higher likelihood of those not guilty and 1 or 2 that would want to accuse on something equal hung? It could. Sure, obviously, the longer it goes, the more likely it is a hung jury, but we went over the percentages one time. It's not a very high percentage. Doesn't mean it's impossible. It could happen. I just never project a hung jury. Wait, what? In my opinion, the only thing proved beyond a reasonable doubt is that it was snowing. Casanova, not including a not guilty checkbox for lesser charges leaves slips vulnerable to tampering, right? So that is true, I guess, if you want to get full conspiracy, which they're basically arguing, somebody could just check that box. But if they did, the jury would know. And when they ask, is this your verdict? They would say, no, it's not. So that would be a major issue. I don't think the Commonwealth or anybody in that courtroom wants to risk that, but we'll wait and see. So let me know in the chat before you go, what are you feeling the verdict is going to be? Guilty, not guilty, or hung? And make sure you guys hit the like button and subscribe on your way out. That's all we've got for this live. I will be keeping an eye on the court feed and seeing what happens. We'll either go for another video today if there's a verdict, or tomorrow, of course. I appreciate you guys as always. But that's all I got. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.